You're watching the legal breakdown. Glenn, it looks like Donald Trump's last-ditch effort to get the core tenet of the prosecution against him in Washington, D.C. thrown out just ran into a wall here. So can you explain what just happened in court?
Yeah, Brian, Jack Smith just filed a brand new 9-page pleading opposing Donald Trump's motion to get some of the charges against him thrown out. And after reading the new pleading, I have to tell you, Jack Smith makes Donald Trump and his lawyers look foolish. And here's why. The charges that Trump is attacking right now are the obstruction of Congress charges, because Donald Trump obstructed the official congressional proceeding, the certification of Joe Biden's election win. He did it in lots of ways. However, we've got to do a little bit of a legal breakdown law school class as a backdrop to understand why Donald Trump's argument that these charges should be thrown out against him is absolutely ludicrous, and why Jack Smith just proved in this new filing that Donald Trump's argument is ludicrous. So Donald Trump set the angry mob on the Capitol to do what? To stop the certification, to stop the steal. He said, go down there, fight like hell, or you won't have a country anymore. Now stop Joe Biden's election win from being certified. And they did. They actually delayed it for several hours. So the Supreme Court, the right-wing bloc of the Supreme Court, swooped in and issued a legal ruling in the cases for the boots of the insurrection. Brian, many of these folks who attacked the Capitol were charged with multiple crimes, including trying to interfere in the congressional proceeding. That is a charge. And what I want to do, it's very short. I want to read the law that we're going to talk about, the law that the Supreme Court said these charges need to be thrown out against the boots of the insurrection. First of all, here's the federal law for anybody scoring at home. It's 18 United States Code, section 1512C2. And it says, whoever corruptly, 1, alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding. So subsection 1 is somebody messes with a document or a record and interferes in a congressional proceeding. Or 2, anyone who corruptly otherwise obstructs, influences, or impedes any official proceeding or attempts to do so commits this crime. So all of these boots of the insurrection, Donald Trump's angry mob who went to the Capitol on his orders to impede or obstruct or influence the certification of Joe Biden's election win, got charged with that crime, were convicted of that crime, and were sentenced on their convictions. Many of them pleaded guilty to that crime because they're like, well, yeah, I didn't mess with a document or a record, but I did otherwise try to obstruct, interfere, or impede, the certification of Joe Biden's win. The Supreme Court swooped in, and being textualists, you would have thought they would have read the law and said, yeah, that's exactly what these convicted felons did when they attacked the Capitol and tried to impede or influence the certification. But they said, no, no, no. That's not what the law means. The law means that if you use a document or a record or false evidence to influence an official proceeding in Congress, or if you use a record or document to influence a proceeding in Congress under Part 2. That's not what Part 2 says. So they ignored the text, the expressed language of Part 2, and they threw out all those convictions. Now, enter Donald Trump and his lawyers. He said, wait a minute. That case is called the Fisher case because the defendant in that case that went up to the Supreme Court, the particular boot of the insurrection there was a guy named Fisher. Donald Trump's lawyer said, the Fisher case, oh, you got to throw out the same charges against Donald Trump if you threw him out against all the boots of the insurrection. And Jack Smith made them look foolish. Here's why. He said, wait a minute. The Supreme Court said, even though we disagree with their interpretation because they just ignored and contradicted the plain language of Part 2, what they did say was that Part 1 and Part 2 both involve the requirement that the defendant, the person who's being charged with a violation of this federal law did so with documents or records or fake evidence. And bulletin, Donald Trump is the head of the conspiracy by which fake elector certificates were created, were signed, were sworn to, were mailed to the Senate and the National Archives. So Donald Trump did exactly what the Supreme Court said violates Section 1512C2. I know that's a bit of a dense explanation, but this is an important filing by Jack Smith that puts the foolishness to the arguments that are being offered by Donald Trump and his lawyers, and I suspect Judge Chutkan will easily deny Donald Trump's last-ditch attempt to throw out that charge.
Well, Glenn, that raises the obvious question here. Jack Smith will present this argument to Judge Chutkan, who I assume, based on everything that we've seen thus far, will accept his argument, but won't Trump have the opportunity to appeal this right back up to the Supreme Court in the way that he appeals everything up to the Supreme Court, and in the same way that they refuse to actually abide by the plain text of the Constitution, they could do the very same thing right here as it relates to Donald Trump?
You know, we've got some consolation here. The answer is nope. This is not an appealable ruling. The interpretation of a statute is not immediately appealable. This issue, once Judge Chutkan denies the motion to dismiss based on this harebrained argument by Trump and his lawyers, cannot be appealed until after Donald Trump goes to trial, presumably is convicted, gets sentenced, then the case is over. Then this issue can be appealed. That's different from the immunity issue. The reason we let defendants appeal immunity issues right away, as opposed to these kind of motions interpreting statutes, is because if a judge gets an immunity issue wrong, in other words, says, no, you don't have immunity, you got to go to trial, and that's incorrect, well, the person shouldn't be forced to go through a trial and wait until he or she is convicted and sentenced to then get their immunity rights vindicated. So an immunity issue is immediately appealable, but almost every other issue, including this one, is not immediately appealable.
And as far as Judge Chutkan making a ruling on this motion that was put forward by Jack Smith, when should we expect to see something like that?
You know, it's a great question. I have a feeling after reading Jack Smith's opposition to Donald Trump's, nonsensical motion to dismiss, she may not even need oral argument on this one. We may see something pretty promptly by Judge Chutkan saying, yes, I've considered the issue fully based on the briefing of the parties, and I deny defendant Trump's motion to dismiss. That would be the way I suspect she's going to resolve it, and it could be very soon.
And Glenn, is this happening completely separate and apart from right now Judge Chutkan considering the 165-page motion against Donald Trump? So we have two separate issues here. One is the 165-page motion to determine whether all of the actions contained within that motion fall under the umbrella of presidential immunity. And then at the same time, we have this effort by Donald Trump to just dismiss one of his charges by claiming that he falls under the umbrella of the Fisher precedent, and they're just happening at the same time, but separate and apart from each other.
Yeah, I would say separate but related. So there are lots of things being litigated simultaneously. For example, Judge Chutkan issued a 50-page discovery order today. Donald Trump had said, I need you to order Jack Smith to go on a snipe hunt for all kinds of information that frankly probably doesn't exist. And Judge Chutkan in 50 pages ruled, nope, I'm denying it about 95% of what you are requesting, but I will ask Jack Smith to inquire about 3 discrete areas to see if there's any information that he should turn over to you in discovery. So there's lots of litigation, Brian, going on simultaneously. The big ticket one, of course, is the immunity issue. That's the one we're waiting to be litigated, waiting for Judge Chutkan to rule, and I suspect she will rule. Donald Trump is not immune from prosecution for what he did, so he should stand trial. That's the one that's immediately appealable, and up through the D.C. Federal Circuit Court of Appeals, it will go to the Supreme Court, and then we'll see if the Supreme Court does Donald Trump yet another favor, or if they remain loyal to the Constitution and deny his presidential immunity claim and give it back to Judge Chutkan. So finally, at long last, we can see Donald Trump go to trial and hopefully held accountable for his January 6 crimes.
Well, you know, to steal one of your phrases, what a difference a judge makes, because this is how the process is supposed to play out. And I think we've just gotten so used to Judge Cannon basically acting as yet another defendant at the defendant's table right alongside Donald Trump, that when a judge actually abides by her oath of office, it really does put on full display how nonsensical everything that Donald Trump and his team try to put forward actually is. So with that said, of course, you brought up a lot of things that we are waiting on in this D.C. prosecution. We'll continue to cover them. So for those watching right now, if you want to follow along, please make sure to subscribe. That's the best way to support our work. And of course, the best way to follow along with everything happening in trial right now. The links to both of our channels are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.